Okay, thank you so much, Kelsey, and thank you to everyone on the line for joining us today. In addition to thanking Kelsey for her technical support today, I also want to thank Lisa Wennett for inviting me to join all of you for what I think is a pretty interesting topic, the best practices for managing your friends' boards. This was a session that we did at the New York Library Association's conference back in the fall in Saratoga Springs. It was a great session, and I'm delighted to be able to repeat it today for all of you on the phone and online. A few bits of housekeeping before we get into our topic. I just have to note that this is a general informational presentation. It should not be construed as and does not constitute legal advice on any specific matter, nor does this presentation create an attorney-client relationship. I encourage all of you to seek advice for your own organizations from an independent legal advisor. I just want to briefly introduce myself and the organization that I work for those of you on the line who may not be familiar with us. Pro Bono Partnership is itself a nonprofit 501c3 organization, and we'll talk more today about what those terms mean. And our mission is to provide free legal assistance for nonprofits in Connecticut, New Jersey, and in New York, we assist groups outside of the 5 boroughs in New York State. And we provide free legal assistance for these nonprofits in a wide variety of areas, excluding litigation. So to be eligible for our assistance, an organization must be nonprofit and tax exempt or seeking to become tax exempt under Section 501c3 of the Internal Revenue Code in our service area, serving the poor and disadvantaged, providing health and human services, protecting the environment, or teaching and promoting the arts, and unable to pay for legal services without significant impairment of their program resources. We do represent a number of Friends of Library groups around New York State. If your organization is not yet a client of Pro Bono Partnership and you'd be interested in becoming one, you're welcome to visit our website and fill out the application for legal assistance. The services that we provide are pretty varied. As I mentioned, we do not assist with litigation, but outside of that, we assist with a wide variety of matters. Of particular relevance to today's topic, we help a lot of groups with their corporate structure and corporate governance. We also assist with reviewing contracts, employment law questions, intellectual property issues, real estate matters, tax law, and regulatory compliance. So that's a little overview about my organization. As Kelsey mentioned, I'm the legal director at Pro Bono Partnership. I've been a staff attorney here for several years, specializing in nonprofit and tax-exempt law, which leads us to our agenda for today. We will be providing an overview in the next hour or so of some relevant laws that affect New York nonprofit boards with a specific focus on Friends boards. And so I've sort of subdivided our presentation into 4 main areas. We're going to be talking about what it means to be nonprofit and tax exempt, the role of the board of directors of a New York nonprofit organization. Then I'll be covering some recent changes to New York laws. There have been some significant changes to the New York nonprofit corporation laws in recent years. And finally, some tips for a better board and better functioning of board meetings. And we're going to try to leave about 10 minutes at the end to respond to your questions. So as Kelsey mentioned, please feel free to enter your questions in as they come up, and I'll hope to get to as many of them as possible at the end. So moving right into our first topic, what does it mean to be a nonprofit corporation, and what does it mean to be tax exempt? So some of what I'm going to cover in the next few slides may be very familiar to those of you on the line who are calling in from friends organizations that have already decided to incorporate and apply for tax-exempt status. But I'm guessing that some of you on the line may be representatives of friends groups that have not yet incorporated and are thinking about doing so. So these slides will talk a little bit about the process of how you incorporate and become a tax-exempt organization and sort of the pros and cons of that approach. So often people use the terms nonprofit and tax-exempt interchangeably, and that's generally not an issue. But specifically when we use the term nonprofit or not-for-profit in this presentation, we're generally talking about a nonprofit corporation. So a corporation is a specific type of legal entity. It is a separate legal entity under the law. It can enter into contracts in its own name. It can hire employees. It can sue others. It can be sued. And the way you form a nonprofit corporation is you file a certificate of incorporation, or what's sometimes called articles of incorporation, with the state in which you want to incorporate. So for those of you who are with friends groups that have incorporated, you may have seen this document previously. It's called a Certificate of Incorporation in New York State, and it states some basic information about the organization, its name, its initial directors, and the mission of the organization. And then once you've formed a nonprofit corporation, then the second step is applying to the federal government to be recognized as tax exempt, meaning exempt from federal corporate income taxes under the Internal Revenue Code. So it is a two-step process, even though people use the terms interchangeably. You do need to complete both steps in order to be considered tax exempt under federal law. And then once you've achieved tax-exempt status under federal law, it's relatively easy to apply for various state and local tax exemptions. In New York State, an organization that has already been recognized as tax-exempt under 501c3 under the federal law will generally be exempt also from state corporate income taxes and on sales tax on items that the organization purchases for its charitable use. If your group has not yet incorporated and you're thinking about whether or not that might be the right option for you, this slide just sort of talks briefly about what are the pros and cons of forming a separate corporation. The major pro of incorporating is that it limits the liability of the people involved in the organization. So, as I mentioned, a corporation is a separate legal entity, and once you form a corporation, it kind of puts a protective shell, for lack of a better term, around the people doing the activities of the group. If you don't have that separate legal entity protecting those people, then there is a risk that individuals might themselves be personally liable for their acts or acts that the group performs together that result in someone's injury or harm. Now, I don't want to make anyone panic. If you're a friends group and you're operating within the auspices of your own library, you may not need to be concerned about liability, but for most people who are doing some kind of activity on an ongoing basis that would qualify as a nonprofit purpose, there's a real incentive to incorporate to provide that additional protection for the people in the group from personal liability. Some other pros of incorporating, it does facilitate opening a bank account because the corporation can apply for the bank account in its own name. It may be necessary for you to incorporate in order to enter into certain contractual agreements. For example, if you throw an annual fundraising event, someone needs to sign the contract with the venue, and that may need to be a corporate entity. To some extent, incorporating does make you more attractive to funders. Foundations and other sort of professional grant-making institutions generally will limit their grants to groups that are formally incorporated and tax-exempt under 501c3. And once you form the corporation, it exists in perpetuity until such time as it is formally dissolved. So if you're doing an activity that has an ongoing time frame and no end in sight, incorporating may be of particular benefit to your group as opposed to someone who's just doing sort of a one-off event. The trade-off of incorporating is that once you have formed a corporation, you are subject to certain regulatory and legal requirements. There are requirements for annual state filings. You do need to then observe corporate formalities, which is the piece that trips up a lot of people, meaning you do have to meet regularly as a board, and I'll talk more about that in a few minutes. You need to document your meetings through minutes and records of your decisions, board resolutions, etc. Having made the commitment to form the nonprofit, you do need to recruit and retain people to carry out the work of the nonprofit corporation. In New York, you must have a minimum of 3 people to constitute a legal board of directors, for example. And then I've put perpetual existence here as well because it is somewhat cumbersome to dissolve a nonprofit corporation. So when we have folks here in our office who are thinking about starting a new nonprofit, we talk to them quite a bit about whether they're prepared to maintain the organization in perpetuity because in many respects it is much easier to start a nonprofit corporation in New York than it is to dissolve it. So as I mentioned, it's a two-step process. Having formed the nonprofit corporation, then most groups will choose to apply for tax-exempt status under Section 501c3 of the Internal Revenue Code. And here I say meaning most friends groups. 501c3 is only one type of tax-exempt organization. There are several other types of exempt organization under Section 501c of the code. But the key feature of being a 501c3 organization is that, generally speaking, it is the form of tax-exempt organization that can accept charitable contributions that are tax deductible to the donor. So many groups want 501c3 status in order to be able to offer that benefit to the people who contribute to their organization. As I mentioned, you don't pay income taxes as a C3 organization. You may also be exempt from sales, property, and other state and local taxes. One of the requirements of being a C3 organization is that there can be no private benefit or inurement, which is a fancy way of saying that the organization has to be formed for a charitable or educational public purpose. It cannot inappropriately benefit the folks who are running the organization, nor can it inappropriately benefit outsiders. The mission has to be generally a public one. There are definitely federal and state registration and reporting requirements that also come with being a C3 organization. The most well-known of these requirements is the Form 990, which is the informational tax return that every C3 organization has to submit annually. There are different versions of the Form 990. Larger groups have to submit quite a lengthy document that provides a lot of information about their finances and the people involved in their organization and their practices. Smaller organizations, meaning those that raise less than $50,000 a year, are generally going to be able to submit a much shorter online filing that's relatively easy to complete. But some version of the 990 has to be completed and filed every year. Failure to file a 990 for 3 years consecutively will result in the automatic revocation of an organization's tax-exempt status. Just two final notes about being a C3. C3 organizations can do lobbying, meaning they can take positions on legislation at the federal, state, and local level, but there are restrictions as to how much lobbying a C3 organization can do. And there is, as of today, still an absolute bar on political campaign activities by C3 organizations. C3s may not intervene for or against candidates for political office, although there has been some talk about lifting that bar in recent months. It is still in effect as of today, March 20th, 2018. And then just briefly on this slide, I've put up a kind of organizational chart to understand the different roles of people within a nonprofit organization. And the nomenclature may be a little confusing to those of you who have not worked in nonprofits before, so I'll just quickly walk you through it. At the top of the slide there, you see the term members. And here, by members, I do not mean the people you call members simply because they donate some money to your organization or they provide a newsletter. I'm talking about members in the legal sense, that's a very specific definition. Members in the legal sense are people who have governance rights in the organization, meaning that they elect the board of directors and can vote on other key corporate matters, such as amendments to the bylaws or the decision to merge with another nonprofit or dissolve the organization entirely. So this is confusing to many organizations because there are a lot of nonprofits that are actually formed as non-membership organizations legally. Their bylaws stipulate that they do not have members in their governance structure, but they call the people who support them financially members, or the people who sign up for the newsletter members. So very few organizations today choose to form as membership organizations in the legal sense because it is quite cumbersome to have this group of individuals who need to come together annually to elect the board of directors and vote on other key issues within the organization. But I mention it here just in case some of you may represent friends groups that are formed as membership organizations, and under your bylaws, that's the document that generally will specify whether or not you are a membership organization, the bylaws and or your certificate of incorporation, and you have some question as to what that means. Most nonprofits, as I mentioned, do not have voting members. Instead, the first line of the chart for them is the line for the board of directors. And here I want to emphasize the slide says directors, and I've been told that for the folks in the Friends of Library world, there's some confusion on this term because you think about directors meaning the directors of the library, and that's not what I mean here. By here, I mean the board of directors of the nonprofit, the people who have been elected to oversee the organization, the nonprofit organization. We'll talk more in the next few slides about the role of the board of directors, but for now, just recognize sort of where they fall within the management structure of the organization. Some organizations will only have a board of directors, but larger organizations will often grow to a point where they will hire an executive director, and that's the term that we use in the nonprofit sector. Some folks use CEO, they mean the same thing, but that is generally, although not always, a paid person, a paid staff member who the board delegates responsibility to for the day-to-day operations of the organization. The board hires and supervises that person, and then the executive director in turn will hire and supervise any other remaining staff, both paid and unpaid, because of course in the nonprofit sector, much of our work is done by unpaid volunteers. So that's generally the hierarchy of a nonprofit corporation. So moving on to our next slide, why do nonprofits have boards? You know, I should have said this earlier, but the corporation is the form of legal entity that the law prefers for nonprofit missions. Generally speaking, nonprofits are not formed, for example, as LLCs or limited liability companies. They're formed as corporations under most state laws. And part of the historic reasoning for that is that in the nonprofit board, you have a group of volunteers who, through their love of the organization's work and their commitment to the underlying mission, have committed to overseeing the programs, the fundraising, the staff, all of the work that the nonprofit is doing. And as I mentioned, in New York, as in many states, there are minimum requirements as to how many people you must have on the nonprofit board in order for it to be legally constituted. In New York, the minimum you must have is 3 people, although most nonprofits have much larger boards than that. And there's something kind of wonderful about this idea that so much of the important work of our society is being overseen by these dedicated volunteers who take on the responsibility of overseeing the organization's work. But really, oversight is the principal responsibility of a nonprofit board. Now, in many organizations, particularly very small grassroots community organizations, and I imagine in many friends organizations, nonprofit board members are wearing multiple hats. Yes, they are overseeing the organization's work, but they're also the folks who are manning the table at the book sale and sending out the letters for the annual fundraiser and maybe running specific programs within the library. And certainly board members can have those like day-to-day responsibilities as well, but the principal responsibility of nonprofit boards under the law is the oversight responsibility that's described here on slide 12, to ensure that everything is running smoothly, to make certain that charitable resources are being used appropriately, and to help raise financial support and awareness of the organization's work. Under New York law, as in most states, there are nonprofit board members, nonprofit directors have fiduciary duties. They are the duty of care, the duty of loyalty, and the duty of obedience. And every nonprofit board member has these fiduciary duties, regardless of the reason they join the nonprofit board. And what I mean by that is many nonprofits have board members who are there maybe principally because they're good fundraisers or their name lends some prestige to the organization's work, and that's absolutely fine. But the important thing to know is that every board member, regardless of the reason why they're on the board, has the same fiduciary duties to ensure the proper operations of the organization. So the duties, as I mentioned, are the duty of care, which is really just a competence duty. It's the duty to pay attention, attend board board meetings, review documents when they're sent to you, ask questions, making sound and informed decisions. It's a reasonable person standard. You have the language there on the slide from the New York Not-for-Profit Corporation Law, the care that an ordinarily prudent person in a like position would exercise under similar circumstances. In addition to the duty of care, nonprofit board members also have a duty of loyalty. They must place the interests of the organization above their own. Principally, how this manifests itself is the expectation that nonprofit board members will avoid conflicts of interest or manage them when they come up appropriately. And I'll talk more about that in a few minutes. But, as a board member, you should not be inappropriately benefiting yourself at the expense of the organization. And then finally, something called the duty of obedience, which is ensuring that the nonprofit is fulfilling its mission. Every nonprofit is formed for some particular purpose. Generally, the purpose for which your nonprofit corporation is formed will be stated in the purposes clause of your certificate of incorporation. And if your organization has applied to the IRS for tax-exempt status, you likely had to provide information about the work you were doing there as well. And so it's the board's responsibility to ensure that that mission is actually being carried out and complying with all applicable laws. The next few slides, I'm just going to sort of run through briefly. There's some practical examples of how those fiduciary duties play out in action. So certainly, the general administration of the organization, there's an expectation that board members will hold regular meetings and elections, that those meetings will be documented through minutes. There's no expectation that you must form committees, but committees may be very beneficial to the proper operation of your board, and I'll talk more about that in a few minutes. I mentioned legal compliance, the responsibility of the board to make sure that the organization is making all required state and federal filings, and obtaining adequate insurance, risk assessment, managing risk, and deciding what level of insurance, if any, is appropriate for your organization's activity is also within the board's purview. Some of these may be more or less applicable to particular friends groups depending on their size. For example, many of you probably do not have an executive director, but if you don't have paid staff, then it's the board's responsibility to pay attention to the finances, to create an operating budget, monitor income and expenses, develop and oversee a fundraising plan and raise money as needed. Very few, if any, of the friends groups I think would be required to have an audit. I'll talk more about that in a few minutes. But for organizations that are required to have annual audits under the law, the board has very specific oversight responsibilities for that as well. Personnel, again, perhaps less applicable to most of the friends groups, but personnel here may also mean management of volunteers and overseeing volunteers and ensuring that you have appropriate policies and procedures and risk management strategies for working with volunteers. Ensuring regular evaluation, engaging in strategic planning as needed, being a good ambassador for the work of the organization to the public. All of these go hand in glove with the responsibilities of being a board member. I'm going to say just a few words here about bylaws. The bylaws are the written rules that govern the meetings and actions of a nonprofit board of directors. Ideally, bylaws should be reviewed and updated regularly to conform to the actual practices of the organization. In practice, I know there are many groups that have their bylaws nicely filed away in a cabinet somewhere and haven't looked at them in years, but they really should be reviewed from time to time, one, to ensure that they continue to comply with the law, and an attorney here who has some expertise in nonprofit corporate governance can be extremely helpful with that. Many folks do not realize that bylaws need to comply with the laws of the state in which the organization is incorporated. And so every year at the partnership, we see new groups coming in for assistance who are formed in New York, but somebody downloaded a set of Michigan bylaws from the internet or got some California compliant bylaws from a cousin. And they really do need to be reviewed for compliance with state law. And then they also need to be reviewed for compliance with your organization's own practices. In some cases, the way the board operates is going to be very flatly dictated by the state law. For example, as I mentioned, you have to have a minimum of 3 board members in New York. But in other places, there's actually quite a lot of flexibility in how an organization chooses to structure its board and the workings of its board. And so again, reviewing the bylaws and working with a experienced advisor who can sort of talk you through your options, find out what your board is actually doing, and then advise on its options under the law for those activities can be extremely helpful. This slide and the next just briefly highlight some of the typical requirements we see in or say provisions that we see in bylaws. For directors, meaning the board of directors, and then for officers. So the typical officer positions that you see on a nonprofit board are president, vice president, secretary, and treasurer. Some organizations prefer the term chair and vice chair to president and vice president. That's absolutely fine. It's completely up to your organization. But the officers are generally a subset of the board of directors. So you have your annual elections. 11 people are elected to the board of directors, and then generally 4 of those 11 will be elected to specific officer roles on the board. And the bylaws will spell out what the responsibilities of those respective positions are. You can have other officer roles in addition to the 4 I just mentioned. Those are just the typical ones that we generally see. And then other provisions that should be in your bylaws, how the board will use committees, if at all. An executive director, if your organization has one. Again, I imagine many of the Friends groups don't. Basic financial matters. When does your fiscal year run? Where are important records kept? Really important for many groups, what are the indemnification rights for directors and officers? So if someone is sued in their capacity as a director or officer of your organization, again, meaning their capacity as a member of the board of directors or an officer on the board, what indemnification can they expect from the organization in terms of the cost of defending that suit and any potential judgment that might come from it. And then finally, the procedure for amending your bylaws. So I'm sorry to sort of breeze through that, but I want to get on to our next topic, which is the Nonprofit Revitalization Act. So in 2014, the New York Not-for-Profit Corporation law changed for the first time in about 40 years, and it changed fairly significantly. And what I'm going to cover in the next few slides are just some highlights of the Revitalization Act, as it was called, to be aware of for your organization. This is most relevant to those folks who are from Friends groups that had previously incorporated under New York law and may not have updated their bylaws or other corporate governance documents pre-2014, and so may not be aware of these changes. So one requirement that changed in New York was that the law now permits notices of board meetings, notices of member meetings, again, if your organization has voting members under the law, waivers of such notice, and authorizations to act by unanimous written consent. All of those can now be sent via fax or email. Previously, because the law had not been amended in 40 years, the statute contemplated that these kinds of documents were being sent in hard copy or mailed to people. So the amendments made it clear that these important documents can be circulated via email. But here I want to highlight for you one area where many organizations get confused. What the law allows is for nonprofit boards to use email to authorize an action unanimously via written consent, meaning somebody proposes to spend $1,000 on an upcoming fundraiser, and under your bylaws, board consent is required for any expenditure over $500. So you need to have a board vote to authorize that $1,000. The board's not scheduled to meet again for another month, but the person who's made this proposal needs the authorization to spend the money next week. What do you do? So you have two choices here as a board. You can either circulate a resolution by email to all of the board members stating this proposal has been made and we're requesting the approval of all the board members to authorize it. every board member must respond affirmatively authorizing the action in order to take that action outside of a meeting. What you can't do under the law is vote over email. So if that proposal is circulated to all of the board members, and you have 11 board members, and 8 of them vote yes, and 3 of them vote no, you cannot proceed with the expenditure. Now, I realize this confuses a lot of people, because if you were sitting in the room at a regular board meeting and you had a vote of 8-3, most likely under your bylaws, that would be sufficient to approve the decision. The reason for this distinction is that the law really favors board members meeting and speaking to one another in real time. So the only decisions that you can make outside of a meeting are those that are essentially there'd be no debate about. Every single board member approves the course of action. And that is why voting over email is not permitted, but approving an action via unanimous written consent is. I anticipate a lot of questions on this particular issue, because when I give this talk, always people panic because they've been doing voting over email and they don't fully understand the distinction that I've just explained. And so feel free to follow up with me after the presentation if you have specific questions. I can't give specific legal advice to your organization if you're not a client, but I can certainly walk you through generally how unanimous written consent differs from voting over email. The other change that came about with the Revitalization Act was that directors can participate in meetings via video conference or conference call, and such participation qualifies as in-person presence at the meeting, allowing the director to be counted towards a quorum requirement. So this makes it clear that if a director cannot be present in person at a board meeting, he or she can participate remotely via conference call or via video conference. And so in the example I gave earlier when I said you need the $1,000 expenditure approved and you're not scheduled to meet as a board for another month, the alternative you have to trying to achieve unanimous written consent would be to hold a special meeting. And you could hold that special meeting via conference call. And every single member of the board who participated via conference call would count as if they were there in person. Because again, the key here is that folks are able to hear and speak to each other in real time, and so you're able to have the same kind of discussion that you would have had if all of you were gathered around the conference table at your typical board meeting. So that is your alternative to approving things outside of meetings via unanimous written consent. You can always call a special meeting, and then you just follow your typical quorum and approval requirements for authorizing action. Briefly here, I just want to mention using committees to get board business done. Committees are particularly helpful for larger boards, but they can be useful even with relatively small boards because they allow the board to sort of subdivide out the work of the organization to specific individuals on the board. There are two types of committees under New York law. We have committees of the board and we have committees of the corporation. And the distinction here is in regards to who serves on the committee and what the committees can do. So committees of the board are established by the board and made up only of board members, made up only of directors. They must have at least 3 directors serving on them to be legally constituted. But committees of the board can be delegated specific responsibilities that would otherwise be the responsibility of the entire board. And the committee can be authorized to act for the entire board within certain parameters. So the classic example of the committee of a board would be your finance committee. 3 people, generally chaired by the treasurer, who have specific responsibilities for the finances of the organization. Often they're the folks who prepare the tax return, who report every meeting to the board on the finances of the organization. In larger organizations, it may be a finance and audit committee who's also overseeing the annual audit. Committees of the corporation can include non-board members, and because they include non-board members, they can't act for the board. So they can't carry out core board duties. So a typical example of a committee of the corporation might be the committee that you form to organize your annual fundraiser. Your fundraising event is not specifically the board's responsibility. That could be shared out among community members as well. And so that's just one example of a committee of the corporation. I want to stress here there's absolutely no requirement that a nonprofit has to have committees. It's just a choice made available to you as a board, but this distinction of committees of the board and committees of the corporation, these are new categories that were created by the Revitalization Act, and so if your organization has older bylaws, you may not have these terms in them. Committees can also be standing versus ad hoc, meaning they may standing committees generally exist until they're dissolved, whereas ad hoc committees are usually formed for a shorter term purpose and dissolve fairly quickly once that purpose is achieved. If you do use committees, this slide just has some best practice tips. You should be documenting the vote creating the committee and clearly define the scope of the committee's authority. You should keep minutes of committee meetings, particularly for board committees, like your finance committee. But they're good ideas for any committee. They don't have to be too formal. You just want to have a record of what the committee is doing, which facilitates the next point, which is making regular reports to the board. Committees should be reporting to the full board on their actions. Keeping minutes of committee meetings makes that very easy. And frequently we see bylaws for nonprofits that list a number of committees that are actually no longer active. And so if your organization has had committees in the past, or your governance documents still reflect committees that aren't really doing anything, then disband those committees. You can amend your bylaws to remove them and end them if you're no longer using them. One of the big focuses of the Revitalization Act was on conflicts of interest and related party transactions, which are a subset of conflicts of interest. I haven't talked to Kelsey about this in advance, but I think we will be able to email everybody a PDF of the slides after today's presentation because I'm going to kind of run through these slides fairly quickly, and they're quite technical, so I understand that folks may want to review the material afterwards, so we will try to get a PDF of the slides to everybody. But briefly, the key point I want to make here is that one of the new requirements of the law is that every New York nonprofit corporation must have now a written conflict of interest policy that complies with very specific statutory requirements. So prior to the Revitalization Act, having a conflict of interest policy was considered a best practice for nonprofit 501c3 organizations, but New York now requires it. And the requirements for what has to be in your conflict of interest policy are quite technical. Big picture, what is a conflict of interest? It's a situation that emerges when a member of the board has an interest. Often it's financial, but it could be a different type of interest that is somehow at odds with the interests of the organization, potentially. There are obviously many different types of circumstances that can give rise to a conflict of interest. And so the requirements for a conflict of interest policy in New York include defining the circumstances that will constitute a conflict of interest for your particular organization. Financial conflicts of interest are the conflicts that most people think about, but there may be others. So the policy needs to define a conflict, set out procedures for how a board member would disclose a conflict of interest, either to the board or to an authorized committee thereof. It must prohibit the person with the conflict from being present at or participating in the board or committee deliberations or vote regarding the matter that gives rise to the conflict. And the policy has to cover your board members, your directors, your officers, and key persons, so people who manage or control all or a substantial part of your organization's activities, programs, and or budget. In the Friends of Context, you may not really have many people who meet the definition of a key person, but in larger organizations, you can easily imagine there's a whole universe of people who will meet the definition of a key person, and so therefore also need to be covered by the policy as well. This slide goes on about more specifically what needs to be in your conflict of interest policy. You need to set out procedures for disclosing, addressing, and documenting related party transactions, which is a specific term I'll define in a moment. And it requires every director prior to their election and annually thereafter to complete, sign, and submit an annual disclosure statement that identifies any entity of which the board member is also an officer, director, trustee, member, owner, employee, and with which the nonprofit has a relationship, and any transaction in which the nonprofit is a participant and in which the director might have a conflict of interest. I mentioned earlier there are all different types of conflicts of interest, but the principal ones that most people think about are financial conflicts, and that's what we mean when we talk about related party transactions, which is the term that the New York law now uses to refer to specific types of financial conflicts of interest. Who is a related party? It's the board members, the officers, and the key persons, and it's their relatives. And you'll see on the slide, it's a whole long list of people who will qualify as a related party. It's your board members, spouses, domestic partners, parents, siblings, children, grandchildren, and great-grandchildren, and the spouses or domestic partners of all of those folks. A related party also may be a different type of legal entity in which one of the individuals described above has a significant ownership interest, defined here as 35% generally. This is all very confusing, I'm sure, and very technical, but it does boil down to some common sense principles, which is that, as I mentioned at the start, every board member has a duty of loyalty to the nonprofit. And so if there are transactions that come up where that duty of loyalty might be compromised, for example, one of your board members owns a printing company, and you need to have 1,000 flyers printed up for your annual gala, and you've sourced out bids for the work, and most folks are going to charge you $500 or more to do the work, but your board member says, I'll do it for $250 because I love this organization. In theory, that is a conflict of interest because your board member is benefiting financially from the transaction. The nonprofit is going to pay them to do the work. But the fact that the conflict exists does not necessarily mean your organization can't go through with the transaction. What it means is that your organization should pull out its conflict of interest policy and follow the procedures outlined in the policy for reviewing the transaction and ensuring that it's in the best interests of the nonprofit. So in this example, board member who owns printing company makes offer to print flyers for $250, explains this is a 50% discount on his or her normal rate, and then excuses themselves from the meeting, and the rest of the board considers that transaction. And in doing so, should be looking at alternate bids to ensure that the transaction is fair, reasonable, and in the nonprofit's best interest. And those decisions should be documented, the alternate transactions that you considered. But in the example I'm giving, it's likely that the offer made by your board member printer is the best alternative transaction available to the organization. And so the board can and probably should approve the related party transaction because it is in the organization's best interest and document it accordingly. There are exceptions to what constitutes a related party transaction, very small transactions, transactions that wouldn't ordinarily be reviewed by the board and are available to the public on the same or similar terms, and transactions that benefit a related party solely because the related party is part of the group of people that the organization typically serves. Again, I'm sorry for whizzing through that so quickly. You will receive a copy of the slides afterwards. You can walk yourself through it more carefully. I'm also happy to follow up with folks afterwards if you have questions. Finally, before we move to our last topic, I just want to say a few words about charitable registration. So charitable nonprofit organizations that are formed, operating, and or soliciting donations in New York State are required to register and file annual financial reports with the New York State Charities Bureau, which is a unit of the Attorney General's office. There are two relevant laws. One law applies to organizations that are formed and holding charitable assets in New York, and the other law applies to organizations that are soliciting contributions in New York. So if your organization is formed in New York and is soliciting in New York, likely you'll need to register under both laws. And so if you're not aware of this requirement and you're not sure whether or not you need to comply with it, I encourage you to visit the Charities Bureau website at charitiesnys.com. There are a number of exemptions to these registration requirements. So go to the website, read through the paperwork if your organization is not already making these filings, and determine whether or not you need to comply. Very briefly, I mentioned as part of this annual report, certain organizations have to file a financial report. Generally, it's either a set of unreviewed financials or a set of financials that have been reviewed by an independent CPA. Large organizations are required to have an audit, and the Revitalization Act changed the filing thresholds. So at the moment, if your organization is raising less than $250,000 a year, or has revenue of less than $250,000 a year, I should say, then you need only submit financials to the AG's office that have not been reviewed by an independent CPA. Larger organizations do have to have the independent CPA review or an audit. I'm going to skip over the requirements for managing the audit because I'm going to assume most folks on the board who are here today are from friends groups that are not required to have an audit, since the threshold is now $750,000 a year in revenue. But you'll receive these slides if you're on other boards that are required to have an audit. It's important to know that the Revitalization Act did put some significant responsibilities on boards for managing the audit and who can be involved in the annual audit, which is what these next few slides are about. Finally, I just want to note for all of you that New York requires when you're hiring outside professional fundraisers or fundraising counsel who are not employees, these are consultants, independent contractors that you hire to advise you on fundraising or to conduct the fundraising for you, those folks need to be registered with the New York State Attorney General's office, and you must have a written contract with them, a copy of which needs to be filed with the Attorney General's office. This is really important. Groups get tripped up on this every year because they don't realize when they're hiring a fundraiser that that person is required to be registered with the Charities Bureau, and the fundraiser, if they're not registered, generally isn't proactively disclosing that to the charity that they're not registered. And then the nonprofit gets in trouble for having used an unregistered fundraising consultant. Grant writers used to be scooped up in the definition of fundraising counsel, meaning if you were hiring somebody to write grants for you as a consultant, those folks needed to be registered with the AG's office. But the Revitalization Act took grant writers out of this definition. So if you hire a consultant to write grants for your organization, and that's all they're doing for you, they are not subject to that registration requirements. You are not subject to the contractual requirements that other types of fundraisers are, although it's always a good idea to have contracts with anyone you're hiring to provide a service. And then just finally, in our last few minutes before we open it up for questions, I've run through in the last 40 minutes or so a lot of important responsibilities for board members, and the healthiest boards are always engaged in self-assessment and thinking about what their boards are doing well and where their strengths lie, and conversely, areas where they could improve. And so these next couple of slides just have some tips here on slide 38. Some ideas for conducting a board self-assessment, looking at the board you have today. Is it a good size? Do you feel like you have the right size for the work that the board needs to do? Are you structured appropriately? Probably not relevant to most of you, but for groups who historically were formed as membership organizations under the law, have voting members, sometimes there's a decision that that structure is no longer serving them well, and so they want to move to a non-membership structure. Do your board members provide a variety of skill sets? Do you have a variety of experiences, somebody who's comfortable with the finances, somebody who's good at marketing, somebody who's good at program administration? You want to be thoughtful about who you're recruiting to join the board, so you get as many various expertises as possible to benefit the organization. How do you onboard your board members? How do you bring them into the organization? Do you do sort of an overview of board expectations when folks join? Do you maybe buddy people up? New board members maybe get a mentor for their board service from a more experienced board member. Do you have a board book? A board book is the set of documents that you provide to new board members when they join the board. and then you update it annually. And it doesn't have to be a physical book in this day and age. Some folks are doing this electronically, but these are sort of certain core documents that all the board members should have. And in the materials we'll circulate after today's webinar, I'll include a handout that we used in the fall at the association conference that lists some of the typical documents that we recommend you think about including in your board book. If you have an executive director or a volunteer doing the work of an executive director, how is the communication between the board and that person? Does the relationship work well? And are your meetings efficient and productive? Are you getting to the issues you need to discuss? Are people coming to the meetings? This is actually what seems like a fairly simple problem that trips up a lot of organizations where if the board has been underdeveloped or people don't fully understand the responsibilities of being on the board and have stopped coming to meetings, are you even able to get a quorum so that you can have a board meeting and make decisions? And certainly there are lots of non-legal strategies that can help promote more efficient meetings, like using agendas and delegating responsibilities appropriately, having people report regularly, and certainly keeping good meeting minutes. At the end of the day, being a prudent board member really comes down to being informed and participating, and just being aware of what's going on in the organization, exercising appropriate oversight, asking questions when you don't understand something or you just want more information, and just staying involved. That benefits the board as a whole, and it benefits the individual board member as well, because if you stopped coming to meetings and decisions are being made and you're not participating in them, you're still responsible for those decisions if you're remaining on the board. And so being a prudent board member, involves putting in the work of informing yourself and working to the best of your abilities on behalf of the organization. And then finally, keeping adequate records, complying with corporate formalities, as I mentioned, keeping minutes, etc., following applicable laws, being thoughtful about your employment practices, and here I also mean how you work with volunteers. If you individually disagree with a board action and it's serious enough that you want it known that you disagreed with the board action, making sure the minutes reflect that. And then finally, being a prudent board member often means resigning from the board when your interest or your ability to commit to the organization wanes. And some organizations like term limits as a way of promoting turnover on the board, but if somebody has stopped coming to board meetings and they still have a year and a half left on their term, organizations should not be relying on term limits as the appropriate mechanism for assessing that person's future commitment to the organization. You should be talking to board members who stopped coming to meetings to determine whether or not they want to consider serving on the board. And then finally, just being active. And here again, I recommend to all of you the New York State Charities Bureau website. It has lots of useful guides. I've put a few of them on this slide, but lots of good information here. And so finally, some information about our offices. I'll also circulate my email address to everyone when we send out the handouts. And with that, I'm done with my prepared materials, and I'm happy to take questions.
Thank you so much, Courtney. We have a couple questions in the queue. The first one is going back to the section on conflict of interest policies. Is it necessary for officers of friends groups to sign those annually, or is the timing dependent on bylaws?
It is necessary for everyone who's covered by the policy to sign a disclosure statement annually. You don't need to sign, it'll depend on what your policy says and your bylaws, but generally how these look, everyone receives a copy of the policy when they first join the board or the organization, and best practices would have them sign it at that time to indicate that they've received the policy and they've read it and they intend to abide by it. Generally speaking, they're only going to need to do that once, but the annual disclosures about potential conflicts of interest should be updated every year, and also should be updated whenever a board member or an officer becomes aware that they do have a conflict of interest. So you may not have had a conflict back in May when everyone updated the policies, but come September you suddenly realize you now have a conflict as a result of some transaction, and so you should disclose that as well.
Great. The next one has to do with sending advocacy letters. Over at NYLA, I know we ask a lot of people to get in touch with their New York State legislators. Is that something that Friends groups are able to do?
Yes, you can advocate as a Friends member. Advocacy generally, so people use the term advocacy to encompass a broad variety of activities. And so here I'm going to remind you all of what I touched on when I talked about the limitations of C3 status. If your Friends of Group is incorporated and has C3 status, there are limits on the amount of lobbying you can do. And lobbying under the federal law may include what's called grassroots lobbying, which are communications where you encourage your members to contact their legislator and take a position on a piece of legislation. Not all advocacy is about legislation, though. If you're doing issue advocacy because of, the importance of literacy, for example, that's not going to be lobbying because unless there's some specific piece of legislation behind your position that you want people to get involved with. So advocacy is fine. Lobbying is also fine, but needs to be paid attention to if you are a C3 organization, so you're aware of the amount you're doing. There are very specific limits on the amount of lobbying a C3 organization can do. So if your Friends of Group is a C3 and is lobbying, you're welcome to follow up with me offline. I can send you some resources to learn more about lobbying. The only other thing I want to say is that if your advocacy involves making statements for or against a particular political candidate for office and you're a C3 organization, there you have a problem because C3s cannot get involved in political campaign activities. They can get involved in nonpartisan political activities, but they cannot intervene in campaigns for a particular candidate.
Okay. And the next question has to do with kind of defining if someone is a member group. They said that their bylaws state members present who are paid members of our Friends shall vote on a slate of directors at the annual meeting. Does that make them a members group?
Mm-hmm. So I can't give you specific advice, but generally I would say that if your bylaws speak in terms of a group of people who have a right to vote, those are voting members under the law. And it's not uncommon for us to see bylaws that say that anyone who donates to the organization is a voting member. That is what that particular organization has chosen as their qualification for membership. And so organizations that have language like that in their bylaws would need to follow that language or would need to consult with an attorney if they no longer wanted to have the requirement of having voting members and then having annual meetings and electing the board. Of course, if that's what your bylaws say and you want to continue doing that and that's working for your organization, those are your choices. So.
The next one has to do with proper email voting. If a motion is made and seconded and then each email under reply all includes a yes vote, would that be a proper email vote?
Yeah, I'm going to, again, push back against the term email voting because you can't vote over email. And so unanimous written consent doesn't really contemplate having a motion that's seconded and then voted on. The way it generally works is the proposed motion is made and everyone just responds approving it. But if everyone on the board has approved whatever has been proposed in writing, and again, the assumption here is that people want to use email for this, but you could also approve it like with a manual signature if you preferred. If everyone on the board approves it in writing, then generally you're going to be, then you'll have achieved unanimous written consent. I also want to add, though, here something I didn't mention. If you're going to use email for unanimous written consent, you should have up-to-date email lists of everyone, email addresses for everyone on your board, and best practice would ask everyone to respond saying, I hereby approve the attached resolution, and type their name at the bottom of the email because that's the electronic signature.
Okay. And then the next question is there an organization who will inspect bylaws and advise needed amendments?
There is. It's called Pro Bono Partnership. You can have any lawyer. You can have any lawyer with nonprofit corporate governance expertise review your bylaws. And I encourage all of you to reach out to folks in your communities who may have that expertise, who do want to do it pro bono or for a reasonable fee. We do this at Pro Bono Partnership. There are other groups around New York State that may be able to provide that assistance as well. For groups in the 5 boroughs of New York City, there's an organization called Lawyers Alliance for New York, although friends of groups may not meet their qualifications for assistance. I'm not certain, but you can look at their website if you're dialing in from the 5 boroughs and see if they could assist you. So there are folks that do this work, but Pro Bono Resources, our organization, Lawyers Alliance, there are some other groups around the state that do it pro bono.
Great. And is there a specific number or a specific amount of times that an executive board of friends have to meet in person?
Oh, that's a great question. How often does the board need to meet? The expectation of the law is that you meet as often as is necessary to get the work of the organization done. So at a minimum, that means you're going to have to meet once a year because you need to approve your financial statements and hold your elections and things like that. But as a practical matter, most groups will choose to meet more often, and probably your bylaws are where you would need to look to see what the specific meeting requirements are for your organization. If your bylaws say that the board will meet quarterly, for example, then the board needs to be meeting 4 times a year or needs to amend its bylaws to conform to its actual practices. So not much in the way of a specific legal standard for how often you need to meet, but it's part of your fiduciary duties as board members to ensure that you're meeting as often as is necessary to get your work done.
Great. And is there, who is responsible for the oversight of a nonprofit board?
So regulatory authority, I assume this is what somebody means. Generally speaking, it's the New York State Attorney General's Office, the Charities Bureau, that is the primary enforcement of the laws we've been talking about today about corporate governance and fiduciary duties of directors. But the IRS also wields some enforcement authority here via your annual Form 990 reporting.
Great.
And then, of course, you have the public and the media and, other non-legal regulators.
Mm-hmm. And do you know of a good example of a conflict of interest statement?
I do not. No, I don't, and I'm not going to be able to share one with the group because they really do need to be tailored for the needs of each individual organization. Mm-hmm. And so this is an area where it's really beneficial for nonprofits to be seeking out informed legal counsel because if you're just downloading a template off the internet, or if you're even using the conflict of interest policy that the IRS puts out as part of the application for tax-exempt status as a sample conflict policy, that likely is not going to comply with the New York requirements. So this is an area where folks really do need to seek out an advisor who knows what they're doing for some assistance in putting a policy together.
Okay. And if you're a 501c3 and are not incorporated, do you need to have bylaws, file a 990, all that kind of stuff?
Good question. So if you're a 501c3 who's not incorporated, that's unusual, but it does happen. You're not required to be incorporated to have applied for the IRS and gotten tax-exempt status. But you would have been required to provide some kind of bylaws type organizing document to the IRS likely when you applied. And so you would be looking to that document. If you are a C3, incorporated or not, you need to be filing your 990 every year. Otherwise, you're at risk of losing your tax-exempt status.
Okay. And for nonprofits, is there a requirement to formally acknowledge donations? And if there is, what form must the acknowledgement take? And is there an amount threshold?
Okay, so here I'm going to provide another handout with the information we'll be circulating. We have an article on our website about acknowledging donations that I'm happy to send out to folks. Mm-hmm. The rules in this area are kind of technical. As a practical matter, it's always good policy to acknowledge any gift that a donor gives you. One, because you want to thank them, but two, I mentioned you may be required to register if you're soliciting in certain states, and so you need to know where your donors are based to be able to assess whether or not you need to register under a particular state's charitable statutes. But I'll circulate that article which talks about some of the specific expectations under the law for acknowledging donations and the form that acknowledgement letters should take. They differ slightly when you're acknowledging a gift of cash versus a gift of property.
Okay. And Stacy's asking why we would need to incorporate.
You don't need to incorporate. It's certainly your choice. Again, going back to the earlier part of the presentation, most groups choose to incorporate primarily because they're concerned about liability for the folks involved in the organization, and often as a first step to getting 501c3 status so that they can accept contributions that are tax deductible for the donor. There's no requirement, though, that you incorporate, at least not under the law. It's possible the library you work with would prefer you incorporated, but those are conversations for you all to have individually.
Okay. And if changes are made to bylaws, who do those changes need to be reported to?
So generally speaking, bylaws are a internal document, and when you amend them, you just need to update your own internal copies. That said, there may be exceptions to that. Some groups, generally nonprofit C3 organizations, are not going to have to provide copies of their bylaws to outside parties, but there are sometimes stipulations. For example, if you receive a lot of government funding, that would require you to make your bylaws available to your funder. And in New York, if you are subject to the charitable registration rules that I mentioned very briefly, because you're formed in New York and or holding charitable assets in New York and or soliciting donations in New York, you do have to provide a copy of your bylaws as part of your initial registration with the Charities Bureau, and you need to update them with the Charities Bureau if you make amendments.
Great. And we have a question about the term unanimous consent to act. Does that mean that okaying a physical meeting to act on motions as opposed to voting motions through via email?
I'm not sure I understand the question. Can you repeat it?
Yeah. It's about the term unanimous consent to act. Does this mean okaying a physical meeting to act on motions as opposed to actually voting motions through via email?
I'm still not sure I'm understanding the question, but I'll try to answer it. Hopefully, this will clarify the issue for the person who asked it. Typically, boards are going to take action at meetings, and your bylaws will say the number of people need to be present to have a quorum, and then what number of people need to authorize the action at the meeting. Often it's a majority of the people present at the meeting need to vote in approval of the action for it to carry. Mm-hmm. When you're using unanimous written consent, the term is unanimous written consent, and so every single member of the board must authorize the action in writing. So if someone responds no to the email or doesn't respond at all, you have 11 board members, 10 respond yes, and one person is radio silent, and you can't get in touch with them to get their written consent, then the action does not pass, and then you need to either let it go or table it till the next in-person meeting when you may be able to vote on it, as I described earlier, with the sort of typical majority threshold.
Mm-hmm. And another voting by email question. Can you clarify if there's a difference between approving an action and approving an expenditure? Do both have to be unanimous?
Okay, I was using expenditure as my example of a type of action that might need to be approved. The types of decisions that will require a board vote will generally vary from organization to organization. Expenditures are a typical example of an action that might require a board vote, but each organization has its own practices about what types of decisions need to be approved by the board and how. So how meaning your preferences for conducting your board business. So some organizations will delegate certain decisions and actions to a committee, and the committee will have the authority to act on it. Some will require a vote on certain actions at a meeting, and so of the entire board. And so no specific requirements that I would be able to get into today, but I'm sorry if the expenditure example confused somebody. So
we have 2 questions left, and the first is, if you are not incorporated, can you write receipts for donations?
So it's not being incorporated that makes you eligible to receive contributions that are tax deductible to the donor. It's having 501c3 status. They're two different things. Mm-hmm. The question is whether or not your organization has 501c3 status, and if it does, then yes, you can and should be issuing receipts to your donors that serve as their proof of their contribution so that they can deduct the contribution on their income taxes. If you do not have 501c3 status and you are issuing receipts to donors suggesting that you do, that is a problem.
Okay. And our last question is, if a friends group formed in New York State is starting a capital drive for a library to fundraise, do they have to be registered with charitiesnys.com?
If the Friends of Group is going to be carrying out the campaign themselves and raising the money, they likely will need to be registered with the Charities Bureau, because that implies that they'll be soliciting donations in New York State. But I stress, I don't know the specifics of your situation, and so the answer is you should go to charitiesnys.com, review the requirements for charitable registration, and determine whether or not they apply to your organization.
Great. Courtney, thank you again so much for today's presentation, and thank you to everyone else for joining us this afternoon, and I hope everybody has a great rest of their day.
Thank you, everyone.